Good afternoon and welcome to episode 16 of At Your Service with Haber and Martinez. I am Mike Haber, and next to me is my associate and comrade in arms, Edward Martinez. And today we had a special guest lined up, but we got bailed on at the very last moment, so we had to come up with something to discuss with you. And we decided to entitle it A Fantastic Voyage into the Mind of a Couple of Lawyers.
A couple of lunatic lawyers. Are you wearing a shirt that says "Law's cool"?
Not only am I wearing a shirt that says "Law is cool," but the Supreme Court is hanging out. And you're a biker. You'll appreciate that.
Yeah, who's on the bike? Which one?
Oh, I don't know. This shirt is older than me. I don't know which Supreme Court this is. This was from law school, so it was from like '88. You go figure it out. It may have been Rehnquist. May have been Rehnquist. May have been John Marshall. May have been Marshall. It's that old. So anyhow, fantastic voyage, right? So in thinking about a theme, obviously I went back and that cult classic 1966 sci-fi movie came to mind for me. That's where they shrink down this group of scientists and military officers in a nuclear submarine, and they inject them into the bloodstream of a Russian scientist who's got a blood clot that's going to kill him, but the CIA wants to bring him back, so they employ this technology. Well, that's kind of what we're going to do here. We're gonna kind of open up our minds to you all and give you an idea of the backside that you don't see. What is it that we?
And don't you hate when that happens?
How
you hate when you don't get to see the backside?
Well, in my case, it's probably a blessing for most. But what is the calculus that we use in things like assessing a new client or a new case? How do we consider the parameters of it? How do we come up with a idea of what it is that we are going to try and accomplish in the case? What I like to refer to as a litigation objective. What contingency plans we put in place. Like, for example, in fact, one of the reasons I thought of this topic today was, holy cow, we need a contingency plan, right? And that's something that we do with all of our cases. No matter what our goal is, we always have a backup plan. There's always a plan B and sometimes a plan C. How do we structure things like defense investigation? How do we coordinate our litigation or our mitigation if necessary? How do we ensure a steady flow of information, maintain and manage the expectations of our clients? And here's a biggie that many of you probably don't think about. How do we, on our end, balance the two hats that we have to wear? Look, there are some big law firms that do criminal defense work, and there are a few law firms with multiple criminal defense lawyers, but the vast majority of the criminal defense bar are individual sole practitioners like Ed and I. We have our own practices.
Right.
They bear our name or a moniker that we decide to use. And we are the principal of that particular entity. Now, we will work with other people. We may have secretaries or paralegals. We may bring in other lawyers to work on particular cases. But overall, it's just us. So on the one hand, we have to wear our lawyer hat with the client. But on the other hand, we have to wear our businessman hat, right? And run our business. Because like any other business, the bills have to be paid. The accounts need to be balanced. The supplies need to be maintained. The time needs to be budgeted. There are the same considerations for a lawyer who runs a practice as there is for a plumber who runs a practice or for any other.
That's one of the things that people when they ask me, what do you think are qualifications that a judge needs to have? One of the problems we have is when a judge, somebody who becomes a judge was never in private practice. They don't understand some of the issues that come up with private lawyers. And how that affects the client, because I know you guys are sitting here thinking, well, how does that affect me, Ed, Mike? How does that affect me? I'll tell you, it affects you because it affects us, how they treat us. So we have multiple clients, and sometimes judges don't understand that telling us to wait around in the courtroom for 4 hours just to find out if we're going to be in a trial is affecting the rest of you because I can't return phone calls. I can't talk to another prosecutor. I can't draft motions. And so they don't understand that just they shouldn't have us sticking around waiting. So these are things that are going to affect you too.
And that's a great point. I mean, even during COVID, pre-COVID, of course, there was no Zoom, right? Or if there was Zoom, we had never used it, or at least not the way it's being used now. So we were in court for everything. Every little matter had to be dealt with live in the courtroom. So, you had some judges, most I would venture to say, would call private lawyers out of turn. Now, that doesn't mean that they were, particularly good at managing their calendar, right? I mean, some of them were much slower than others, but others took care of business, very professionally and quickly. Either way, while you're sitting there, you have a public defender and a prosecutor who's assigned to the courtroom, has to be there all day long anyhow. And some of these judges don't call private lawyers. They just let us sit and go right down the 47-page calendar case by case by case in order that the clerk printed it. So yes, that is a good example of a parallel of the business of being a judge, right? It's not just getting up there and calling balls and strikes. You also have to manage your courtroom. You have to balance your audit. There are things that you're required to do that are above and beyond simply making rulings. And the same applies for us.
And that's how it affects our clients. So you guys can see how, and this is what we have to do. Well, we have to budget if we have a judge like that. How we're going to get back to the office. What are we going to do? I'm sitting here for 3 hours. What can I do? There's something I can already do at least on my phone. So these things affect you too. And that's, I think, something you guys might want to do.
And by the way, during Zoom, don't think it's gotten any better, because you and I both, Ed, sometimes you and I are sitting here texting with one another while we're sitting waiting to be called on a Zoom calendar for 2-3 hours, sitting there rotting, waiting for the judge to get around and call. But at least the nice thing about Zoom is, you can leave your iPad sitting to the side while you're working on your computer and at least get something done, unlike being in the courtroom.
I can draft a motion while I'm waiting for the court to call my case.
So balancing the business aspect of the law with the practice of law is really important for us. And I'll give you a great example. Ed, you can chime in when you want, but I'll give you a great example of where this comes up regularly. So when it comes to fees, and we'll talk a little bit more about fees, about how we quote them and how we decide on what a given fee will be. But in most of our cases, I would venture to say 99% of my cases, I charge flat fees. That is, I come up with a number, I reduce that number to writing, and that is what the cost of the case is. Obviously, the best case scenario for the client and myself, as it turns out for the client too, is to pay the fee in full upfront. Why? Because every minute that I have to spend worrying about fees and accounting and billing is one less minute that I'm wearing my lawyer hat and worrying about your case and your liberty. So the less time and attention I have to pay to that, the better. That said, many clients are really good about it, and I don't ever have to spend a moment. We agree in writing that they're going to finance it, X dollars a month over X period of months, and they simply make their payments and that's it. But when they don't, guess what? Lawyer hat off, accountant / businessman / bill collector hat on. Right?
Exactly. Absolutely. I think, and I'll tell you honestly, for my clients, Mike, I'm sure you're the same. My clients are much better off paying me a flat rate. I always underestimate how much, not on purpose, but am I wrong? I don't do it on purpose. I really got to estimate how long it's going to take to resolve a case, and 90% of the time.
Let's talk about fees and how we arrive at them, because I think that's something, again, that people may know or they may not understand, and if they don't or they do, either way, they may be interested in our thought process. How is it that we arrive at a fee on a case? Now, if you walk into many let's just say a civil law firm, and you want to hire them to draft a contract or to draft a premarital agreement, a prenuptial agreement, or a postnuptial agreement, or stuff like that. Or if you want to go to a PI lawyer, right? You're going to get either an hourly rate or while sometimes we do hourly rates in criminal, it's very rare for me because, frankly, I hate tracking hours. Again, it's time away from my lawyer hat where I have to sit there and write everything down in terms of time and what I did was that, where I was, and who I thought. It's just a waste as far as I'm concerned. So how do we quote a fee, a flat fee on a case? Well, the general idea is we want to quote a fair fee. And when I say fair, it means fair to me as the service provider, meaning I don't want to be underpaid for my time, but it also means fair to the client because I don't want to overcharge them either. So we try and, at least I try and look at the case from a global perspective. What is the litigation objective in this case? What are the known facts in the case? What are the unique properties of the client that I have to deal with? Who is my judge? That's, we talked about that, inadvertently a moment ago, but that's a huge issue because some judges make litigation extremely difficult, whereas other judges make it a pleasure and simple. So if you're in front of one particular judge or another, I might up the fee on something that I would call an informal judge tax, right? Sometimes you have premiums based on the nature of the case. So you may have a case where a client has a minimum mandatory, or where a client has some other significant issue that aggravates the case above and beyond what it would be for any other person. Another factor would be like the client, him or herself. Some clients are just very needy, and they have either a willful or an inadvertent inability to distinguish between a lawyer and a therapist, or a babysitter, right? And so we call that a babysitting tax. If a client requires significant time, it's fine. I don't mind giving them extra time, but if they're going to take that time away from other clients and away from my own quality of life, they're going to pay for it. And again, just like judges, they come in all shapes and sizes. Some clients are just needier than others.
But let me interject for a second. I want to interject for a second on when clients do that. And I'm talking to everybody out there who's not an attorney, because I know the lawyers will understand what I'm about to say. If you feel that strongly that you got to talk to your lawyer and tell him what to do, you've hired the wrong lawyer, right? I don't hire a mechanic and then tell him how to fix my car. If I got to tell my mechanic how to fix my car, I've hired the wrong lawyer. So for you to think that a lawyer is going to talk to you about how to defend your case, he wants to get input on your facts. But once he gets the input from your facts, a good criminal lawyer knows what's going on just from reading the A form, right, Michael? We know. We've been doing this for over 20 years. We know what the cops left out. We know what isn't said. We've seen thousands and thousands and thousands of them. So if you're hiring a lawyer and you still feel like you want to talk to them and tell them what motions to file, and how to defend you, and whether it's a good case to go to trial or not, you've hired the wrong lawyer. You probably paid very little. And if you feel that you paid very little, and that's why you got a lawyer that you got to tell them how to handle your case, I'm telling you, would you feel comfortable hiring a mechanic just because he's cheap, but you still got to tell him how to fix the car? You want to do that. You want to hire the right guy. You don't need your lawyer to babysit you. That's what your family is for. That's what your friends are for, not us. I'm not your babysitter. I didn't grow up with you, and you don't have 20 years of experience, almost 30 years of experience that Michael has, or over 30. How would you have now, Mike? 30 or over 30? Well, you're getting old.
I'm at the 30-year mark now.
You're old, man. You are getting old. But Michael's been doing this for 30 years. There's nothing you're going to tell him. And you trust me, don't want Michael Holt babysitting. I don't want Michael babysitting my dog.
I will tell you, that said, it does happen. And I have empathy for many of my clients.
So do I.
And I don't mind going the extra mile, but I'm very careful to tell the client that which we're discussing right now. Look, how do you want me to spend my time on your case? If this is what you want me to do, it's going to cost you more because it's going to take away from other clients who don't require this type of attention. I always recommend, if I have a client who is what I would call a needy client, right? I try to put them in therapy. It manages the client. It keeps them on an even keel. It gives them somebody to talk to who's really competent and qualified to deal with those types of matters. And it frees me up to do what I need to do. Plus, it always dovetails into that plan B or C, which is the inevitable mitigation issue. Because ultimately, you never know what's going to happen in a criminal case, right? The only absolute in criminal litigation is anything is possible. Whatever's probable is another story, but anything is possible. So you can go into a case, and I'm sure it's happened to you, Ed. I know it's happened to me. I have gone into some cases so absolutely convinced that I was going to win and then been shocked with a loss. But by the same token, I've gone into more cases absolutely convinced that I was going to lose, yet walked out a winner. So you never really know what's going to happen, and you have to have backup and contingency plans. One of those plans always has to be, what if I lose? What if the client comes up short? And that's where you have to be prepared for mitigation, right? So if you do have a needy client who does agree and is amenable to going into therapy, all of a sudden you've got months and months of therapeutic records and a meaningful therapeutic relationship to rely upon when it comes time to go in front of a judge for mitigation. So, you got a dual advantage there in terms of doing that.
But there's another plan B that we use, which is even before the case is over, right? So I'm sure, Michael, when we get a case that comes in, we assess it almost like let's say, I don't know, a game plan for a football game. We look at it, and there's a lot of times there's more than just one way to attack it, but we choose this is the best way. This is what we believe is the right way. We call that our theory of the case. So, right, we think, what's the theory? What's my defense theory? I think this is the best theory. But we've got to be amenable to an alternate theory because, as you said, things happen. And sometimes it happens in the middle of a trial. Sometimes a witness says something that nobody had ever heard before, and something comes up in the middle of a trial.
So,
we got to be ready to switch.
For an example on that, about 2-3 months ago, I did a stand your ground hearing, and you were in the audience watching that hearing. And while the alleged victim / complaining witness was on the witness stand testifying, he bragged actually, about human trafficking. Do you remember that?
Oh, right.
Remember when he said that he had gotten an escort from out of state and flew her in to, and so everybody except the prosecutor who apparently wasn't fazed, but everybody just stopped and went, wait a minute, did this guy just admit to human sex trafficking? A curveball that came out of nowhere, right? So, these things happen.
I said, you got to be ready. And mine happened in the middle. I remember a case in the middle of a trial where it went bad for the state, right? So I had really nothing. We really had really, where I had my theory, which my theory of the case was this, my client didn't really know what was happening. Trial, when confidential informant testified, everything that his alleged handler, the cop that was supposed to be handling him, said, this guy said didn't happen at all. So there was supposed to be a meeting beforehand where my client and the co-defendant had given him a sample, and he took the sample back to the DEA. When he's sitting on the stand and I'm questioning him about the sample, he says, yeah, they gave me a sample. And I'm like, okay, and that's when you took to the handler. He goes, no, I didn't. I said, what'd you do with that? He said, I took it home and put it in the drawer in my house. So the handler never saw that? No, he never saw that. You never talked? No, he didn't do that. What about when they frisked you before you went in? Nobody frisked you before I went in to make sure he has no drugs on him. So I had to really, right there at the podium. But I was ready for plan B. Why? Because I've been a prosecutor for so many years, and I know that CI some say the stupidest things on the stand. So I was ready for plan B. Here's the most important thing, Michael. Right? Hear me out. For everybody who's out there listening, here's the most important thing you need to understand when you're talking to your lawyer. He needs, or she needs, to know everything, the truth about everything. Because if you don't tell us the truth about everything, when we start doing this in our heads, we are planning a contingency and a plan for something that's not going to work. Because you're not telling us. We're going into battle thinking everybody's got BB guns, but you forgot to tell me that, oh, by the way, I had handed them a couple of bazookas. You need to tell us everything so we know where to go. Right, Mike? How many times has that happened to you?
Well, running with that, let me just add to that by saying a good criminal defense attorney, a seasoned criminal defense attorney, is never going to judge you. That is not our job. We don't care if you're guilty or innocent. It doesn't matter to us. When you're hiring us to do a job, which is to challenge evidence and to make sure that any violations of your rights are remedied and that no further violations occur from the moment that we're brought on board. We are not there to judge you. We are there to defend you. In fact, I have a shirt that says, my job is to defend your ass, not to kiss it. But it may as well say, my job is to defend your ass, not to judge it. So we don't care about guilt or innocence. Ed's 100% right. What we care about is knowing what we need to know in order to effectively represent you. And I just want to go backwards for a minute, because I don't want people to think when we talk about, babysitting or client control, stuff like that, I don't want that to be confused with open and honest dialogue and the free flow of information, because It is exceedingly important that an attorney keeps his client or her client 100% informed about everything that goes on in their case. The client must know. One of the really nice things about our technological era that we're in is that most of the correspondence that we get, unlike the old days, I mean, when I first started practicing, the internet existed, but it wasn't like it is now, and it certainly wasn't mainstreamed or used. And so we dealt with paper files. And when we needed to get copies of stuff to our clients, there was no scanning and emailing PDFs. It was hard copies at a photocopying machine, adding toner, getting it all over your freaking shirt and hands, stuffing it in an envelope, paying postage. I mean, it was a nightmare, to be perfectly honest. So with technology today, every single item of discovery, well, I mean, in the absence of larger stuff that needs to be put on a flash drive or a DVD-ROM, but still, even in that capacity, every single item of discovery is simply a file transfer away. And so whenever I file a motion or communicate with the court or with the prosecutor, I BCC my client. Why? Because there's a record. Not only is there a record for them, but there's a level of protection for me. Again, this is my businessman hat that I'm wearing, right? I don't want my client to ever say, well, Haber never told me this, Haber never sent me that. And why is that important? Well, I'll give you two good reasons. The first reason is I got to go out and say, I don't have an actual statistic for you, but I believe about 40% of my active client files are cases that I inherited from other lawyers who either screwed up the case or pissed off the client and got discharged, and they wound up coming to me.
Right.
But the second reason, which is even more compelling, is that it is an ethical requirement. The rules regulating the Florida bar, the rules of professional responsibility, require us to maintain contact with our client and to keep them, the exact language is, reasonably informed. I don't believe reasonably informed is enough. I believe fully informed is required, and so I go the extra step. So when any of those 40% come to me, I've got to go break that down and say probably 80% or more of that 40%, when they first come to me, don't even have a copy of their arrest report, much less any of the discovery that's been tendered by the state. They have nothing. And so in order for me to evaluate the case, the first thing I say to them is, look, you got to get this information. And I never trash talk other lawyers, even if I think they're idiots, even if I know they're idiots. I keep it to myself. But it always burns me up on the inside because it wants to come out. I want to say to this guy, how could you have somebody with your life, with your liberty, with your history, your criminal record in their hands, and you don't even know what time it is? You have no clue. It's mind-boggling. But
right. And
so
I want to make sure I'm clear too, Michael. It's not
Sure.
It's not talking about the case. It's not asking things, not telling us, hey, you know what, when they sat me here, they didn't read me Miranda. It's not that. It's once we have certain conversations with you, we have certain conversations with the client, coming and telling us, file this motion, or you can file this motion because he didn't read me Miranda, for example, things like that. But when he first arrested me, he never told me what he arrested me for. First time it comes up, we explain it to him. Well, that's not an issue. It doesn't matter. But for you constantly to say, back to the jail to talk to me. I want you to can we revisit that issue again? I talked to a friend of mine who said, guys, if you don't think we can do the job, then hire somebody else. Now, if you want to ask, hey, Martinez, what happened last time in court? Well, this is what happened. Not much, because the prosecution wasn't ready. Well, why weren't they ready? Because of this. Is there anything we could have done? All those conversations, absolutely. That's what a lawyer has to do, and we do. I'm just saying, sometimes and like Michael said, to take your phone calls, every cousin tells you about you should be fired. We'll do it, but then I charge you by the hour because you're going to be taking up a lot
It's
more time.
it's even worse than that sometimes. It's like we call it bartender syndrome, right? And you were a bartender, so sometimes people just want to talk. Okay, they need a friend.
I agree.
Maybe they're afraid. Maybe they're afraid to talk to their family. Maybe they don't have a significant other. Maybe they've got no friends. Right? What is it? Jack Nicholson says in A Few Good Men. Maybe Private Santiago didn't have any friends. Maybe he didn't have anybody to call. Maybe he likes to pack in the morning. I'm an educated man, but I can't speak intelligently as to the travel habits of Private Santiago. Right? Look, there are people like that. So I understand. But again, I'm very upfront with them and say, look, either A, it's not going to happen. I can't represent you because, I just can't handle it. Or B, if I am willing to do it, then you're going to get charged for it. Because again, it's either you're taking away time from other clients or you're taking away time from my personal life. And I don't mind giving the extra time. I will definitely go the extra mile. I don't think you're going to find any client of mine who's going to say that I haven't done that or I'm not willing to do it. But fair is fair is fair is fair, right? If you want to sit down at the poker table, you need
it's hard
to
to explain, but I think the way you put it is the best. I think the best. You explained it the best way.
I'm not used to those sorts of compliments from you.
It's the ones that have good balls.
So let's talk a little bit about
it's the ones that like basically make you feel like they got no friends.
I couldn't hear you. You got choppy there.
You there, Michael? Did we lose you?
Yeah, you got. I don't know. Is it me or is it you? Somebody got. Okay. So let's talk a little bit about client interviews and assessing clients and what goes through our mind, our thought process as we do this. And normally, I would say the bulk of these things start with a contact from a client. Well, obviously, we're not out there, soliciting clients, so they come to us one way or another. And some of them want to tell us their story. Some of them have paperwork to provide to us. Some of them want quick answers. There's a variety of ways that they can come at us. But I have learned over my period of doing this work that the most reasonable, responsible, and effective way for me to assess a case is to tell the client, before you tell me anything, before I hear anything from you about this case, stop. I want to read the police report. I like the statement of probable cause from the government to be my starting point, to be the fulcrum from which I decide which way I'm going to go with the case. Because if you believe everything in that document, if you accept everything in it is true, then that must be your client's worst case scenario. Right. And if we read that document and there are things that glare out at us as being questionable or outright wrong, then we have a good idea of where our defense is going to go. But I don't want my client to tell me why he's not guilty or where the police screwed up. To use your example, well, they never read me Miranda, so the case has to be tossed. I want to come to those conclusions for myself and then interview the client and ask them to narrate what happened and then plug in those specific gaps or fill in those gaps or answer those points where I do have a question. So I think the fundamental starting point has to be with the statement of probable cause. Unfortunately, when you get arrested, you're not entitled to the government's evidence. The only thing that you're entitled to, and oftentimes the only thing that you have, right, but oftentimes, the vast majority of times, all you have is a citation, a promise to appear, or a statement of probable cause in the form of a PC or an arrest affidavit or a complaint. But sometimes you have more, right? If a search warrant is served, maybe you have a copy of the warrant that they left there. Maybe you have the affidavit, maybe not. Maybe some records are available in the court file, maybe they're not. We try and look. We want to gather as much government-focused data as we can so that we understand where the head of the state is at, where the state's head is at, right? And in that way, we have a good idea, not only what the case is about, but where the case is likely to go. And the client may change that based upon what they tell us, right? But that's got to be the focal starting point.
And that's why I like doing it that way too.
Go ahead.
I like to read the A form. Sometimes you get the A form, and that's the least we can get that 90% of the time. I like to read it, and then, like you say, interview the client, because as the client is talking, I've already seen things on the A form that are of concern for me. So I've got that highlighted in my head. I'm really focused in on hearing that part. However, now they're filling in things that are not in the A form, that some of it might matter. Hardly ever does it, to be honest with you. I'm sure Michael will tell you 90% of the time when I'm reading the A form, it's not just what's in the A form, right, Michael? Sometimes what's not in the A form is just as important as what's in it.
Reading
So
between the lines.
you're not going to see it because you say, oh man, I read that report and the cop didn't write this down. But Michael and I already know that because we've seen thousands of these and we can kind of tell what's going on. So I like to go there first.
But there's no question that interviewing the client is absolutely necessary. I'll give you a good example. Any standard DUI case, you're not going to know where the client was, who the client was with, what the client had, how they paid the bill, where, if there was a bill, was it paid by credit card or cash? Are there other people who are willing to come forward and give a statement? None of that's going to be in the police report, right? Does the client suffer from any medical condition? You're not going to know any of those things more than likely from the police report. So clients can be very helpful in that vein in terms of telling you. The other thing, a lot of times you get a client who says to you, look, the truth is the cop was a dick and I was a dick to him. Right? And that helps too, because you won't know that from the police report. The cop's not going to write, whereupon the defendant was a dick. No, but if the defendant tells you that, it's going to help you in terms of your thought process of how you're going to deal with the case. Because a police officer who feels like he was mistreated or abused or disrespected may have a chip on his shoulder and go out of his way to try and push something that doesn't necessarily fit inside the hole.
Or it might explain why I'm looking at a case thinking this cop had zero probable cause. I have no clue how this cop would have arrested this guy. But now what you tell me is, well, he did this, and you tell me, the client tells me he did something that was really respectful to the cop and everything got out of hand. Now I'm thinking, oh, okay. Even the cop knows that he didn't have probable cause. He just wanted to do what they call, you can beat the rap, but you can't beat the right. You pissed him off, and he just wanted to arrest you, which means it's probably going to be a very easy case to resolve. But so, Mike, right, again, just piggyback. Look at that. Twice that I told you did something right.
No, I'm not used to this. So how do we determine goals, right? I mean, obviously, what did you call it? You called it I call it a litigation objective. You called it a primary, I forget the language you used for your theory of the case, your goal. Your theory of the case, right. I use those very differently. For me, the theory of the case is, if I'm going to litigate a case, what is my overarching theme? That's what I refer to as the theory of the case. But I understand what you're saying.
So because it all has to fit.
For me, what I'm talking about here is a litigation objective. That means when I sit down with the client and she and he or she and I decide, okay, this is what we want to accomplish. This is our end game here. We want to file a stand your ground hearing and get statutory immunity. We want to get diversion. Whatever the goal may be for that particular client in that particular case, I call my primary litigation objective. But just because I'm shooting for that particular goal does not mean that we're going to get it. Again, right? There's no guarantees in litigation other than anything can happen. And so if you're going to follow the Boy Scout motto, be prepared, or as I was taught, the rule of the 7 Ps or the law of the 7 Ps, proper prior planning prevents piss poor performance, you always have a contingency plan. So just because I decide that I want to file a motion for statutory immunity, I have to figure well, that's great. If I get my client immunized, the case is over. But what if the judge denies the motion? Well, then I need to prepare for plan B. And that means we may have to litigate. Maybe we're going to take an appeal, an interlocutory appeal, before we litigate the case and try and challenge the judge's denial. Or maybe we're just going to say, you know what, the hell with it. the stand your ground hearing was great. We got sworn testimony to work with. Now let's take this puppy to trial and put stand your ground in front of a jury instead of that idiot judge who denied my motion. So that would be a secondary litigation.
And when you say idiot, you mean that with love.
Depends on the particular idiot, I would say. No, some of them I do not mean it with love. But, listen, again, even the best judge can make a bad ruling, okay? I mean, that's just the nature of the game. But you expect bad rulings from bad judges who, in our experience, tend to either look, you cannot deny that there are judges that you and I know, and pretty much every lawyer in the building knows, it's an absolute waste of time to prepare and file and litigate a motion to suppress, because it ain't going to be granted in a billion years. Right. Jesus could walk.
Unless the lead detective himself comes in and says, yeah, no, we fucked up.
Even still, it might not get granted. But so anyhow, we know this, right? All things equal, you want a neutral, detached, honest judge. And that's what we hope for in every case. And I think most judges, really strive to be that way. But there are fringe judges. There are fringe judges out there, just like there are fringe cops and fringe lawyers. It exists. It's a small percentage, but it's out there. Either way, we have to think about these things when we're considering where we're going to go with the case. If I have a judge who I know there is a virtual certainty that any defense motion I file, no matter how well taken, if the judge has the discretion, they're going to deny it and push it to a jury because they don't want to be the one to kick it, then I have to factor that into my case, right? I have to factor it into my plan A, my plan B, and my fees. Because when it comes down to fees, even though we're not charging by the hour, what you and I are really doing is we're doing our own mental calculus. Correct. Given the objective, given the circumstances, given the client, given the judge, given the charges, with all of this in mind, the global picture, how much time do I believe I'm going to need to expend? And at the value of my time, what is the cost of that particular case? And that's why when somebody, and I mean, this happens so often, where a potential client will call me and say, all right, I got a DUI, how much? And I have to say, I can't answer that question because your DUI is a different DUI than every other person's on the planet. And so I need to know a little bit more before I quote a fee. I don't quote fees based on charges. Now, if you hire certain lawyers or certain types of lawyers, like, for example, if you go to the ticket clinic, it doesn't matter what your ticket is. They have a flat fee for tickets, right? I mean, it's different if it's a criminal infraction versus regular infraction. But if you get running a red light or you get a speeding ticket or it's no difference. The fee is the same. It's a flat rate. It doesn't matter who you are or where you got it. Criminal is very different. So in criminal, if you have a criminal lawyer that says, oh, and they advertise, because I've seen this, in writing. Oh, $14.99, $5.99, $24.99. How could you possibly do that unless you're running an absolute mill that pays no particular attention to the unique facts and circumstances of a given client or a given case? So when I do that calculus.
Even in the ticket clinic, Michael, notice what they do, because that's something I wanted to also bring up here in this situation. One of the things that we also, at least I take into account as well, is I ask the client, what do you want? Are you looking for a good offer? Are you looking for a probation offer? Or are you looking for a dismissal regardless?
But that goes, Ed, that goes back to the original point of seeking a litigation objective with the client. You have to find out what the client wants.
But I'm saying two things. That's one of the considerations, because not that we want to charge you more because we're going to believe in your case more if you say we want to take it to trial or get a dismissal no matter what. It's that it's going to take more work. And the ticket clinic itself, yeah, they give you a certain a flat price for all, for every speeding ticket, regardless of who it is. But the only thing they guarantee is no points, because they know how the system is set up, and they know that.
Well, hang on. Let me clarify that, okay? Because first off, I want the audience to be very clear on this. There is only one guarantee that any criminal lawyer is allowed to give you, and that is that they will use all of their skill and experience and mastery in the rules of evidence, the rules of procedure, the art of cross-examination and jury selection to give you the best shake possible. We cannot guarantee you any result. And even the ticket clinic cannot guarantee you no points. What they guarantee you is your money back if you get points. They don't guarantee you no points.
Correct.
So that, just to be clear on that.
But they only guarantee you that, because what they're looking at is they've made the decision already without asking the client, so to speak, that they're going to work on these cases only if the clients are willing to take a plea of a withhold. If you call them and say, no, I want this case to go to trial, they probably would charge you more. Not because we don't.
I don't. In my experience, I don't think that's accurate.
Let's use our experience.
In my experience with the ticket clinics, they are mills. It is the definition of a mill. If you show up and you want to go to trial, it's the same fee. It doesn't matter. It's a traffic ticket. The trial takes all of 3 minutes.
You're right. Let's just use our example. The point is this: if you want to have a case dismissed, no matter what, it's going to be a lot more time that we have to put into it. So you got to ask a client, what do you want now? Suppose a client comes in and says, listen, if you can get me a probation offer, I'm fine. That doesn't mean Michael and I are not going to look for a way to get it dismissed or maybe file a stand your ground motion or anything. But we now know if we get what you're willing to take, what your offer you want, that's something more realistic. So I'm looking at the fee and thinking, okay, this is a realistic fee because what he's willing to take, I could probably get with a little bit of negotiation. Doesn't mean we're not going to push it and try and get a dismissal or argue any kind of motions that are unconstitutional.
Let's take an example of a first non-complicated, just a simple plain Jane first DUI here in Dade County. If you have no excludable criminal past and you have no accident, no kids in the car, and you don't blow over a .25, I mean, if there's no aggravating factors, anybody in Dade County with that first plain Jane DUI is entitled to diversion. It's on the table for anybody. So it doesn't matter what lawyer you go to, or even if you go to a lawyer, if your position is, I want diversion and I don't care about anything else, you could save yourself a whole lot of money. But I think what Ed is trying to explain to you is, while we will put you in diversion if you want us to, we need to make sure that you understand that that's not your only option. Now, if you decide to make a knowing, intelligent, and voluntary decision that that's what you want after hearing your options, so be it. We're happy to help you. But at the end of the day, here's the deal with that DUI diversion program. You can go to court on your arraignment and get enrolled in diversion for $0 out of pocket in terms of legal fees. Now, there, of course, are costs associated with diversion. But you could do that on your own. But here's what you give up in doing that. You do not have a lawyer reviewing the facts and circumstances to determine whether or not there was actually probable cause for arrest, to figure out whether or not there is any basis to suppress or to dismiss a factual, a legal, a procedural, a substantive mechanism to use to attack the case without having to go into diversion. You don't know whether or not you have viable motions. There's nothing that you will know other than I'm going into diversion. Now, that may be enough for some people, but you also may or may not know that you get one bite at that apple. You don't get another shot at diversion after you've taken that one. So if there's a way to beat your case without diversion, maybe you want to save that card for another game. What you also don't know is whether or not you have the ability to beat the case, right? So you may decide, I want to save a couple of dollars here, but being, penny smart and dollar foolish. You don't want to necessarily make a decision that's uninformed. So when we do that math and we do that calculus, we're going to explain that to you, including the fact that diversion is an option. I would say, for most people, it's really a function of dollars. If you can afford to do it, the smart, prudent thing to do is to investigate the case, because diversion will still be there at the end of the day if you want to take it, or even worse, if you have to take it, right? But what you won't know if you don't invest the time is, do you have another alternative? Is there something other? Oh, and by the way, the other thing I was going to say about diversion is, once you accept that BOT program as a condition precedent to getting into DUI diversion, you have to basically sign a confession. So
Not
if
basically.
for
You
some reason,
absolutely have, it's not basically, you absolutely
right,
not only sign
it's
a
it's actually
confession,
a document that's called an acceptance of responsibility statement. So
right?
what happens is,
And
if you get bounced out,
you also
go ahead.
document that says that you agree that if this case goes to trial, that document will be entered into evidence to the jury, so that the jury sees.
So if you get bounced out of BOT, out of diversion for any reason at all, your admission, your acceptance of responsibility is coming into evidence, and now you've just really complicated your case. Look, we want the best for you. That's the really, I think, if you were going to sum up how do we assess cases, assess clients, determine goals, and quote fees, I think the answer to that question is, what we do is we employ, in my case, 30 years, in Ed's case, 20 plus years of experience in figuring out what are your realistic, not pie in the sky, Santa Claus, pot of gold at the end of the rainbow fantasy leprechaun wishes, but your realistic alternatives, and what will it cost to get there. That's what we do. That's how we assess it. And so we use a variety of factors. So again, does that do what?
You lost you there.
What?
Or
Yeah.
you're getting rated. You're getting rated?
Sorry. Yeah, I had an air raid.
Leave your place. Don't talk,
I was
Michael.
trying to.
Read the fifth.
I was trying to hit the end button, and I wound up SOSing my phone. Had a little technological breakdown there. So look, we want the best for our client, and I call my practice personally, I call it a boutique law firm. And some people make fun of me because they're like, "Oh, boutique, what are you selling? Prada purses?" No.
Actually, you do. You do that at the You have them there in the waiting room.
It's a personalized service. Boutique meaning I tailor my service to your needs in your specific and individual case. And that is, I believe, the way, the most responsible way for a criminal defense attorney to approach any given case. I don't care if you're a multimillionaire or if you are indigent. Not indignant like you, Ed, but indigent. I don't care if you are, live in the penthouse of a building or you're homeless. None of these things should matter to a ethical, responsible, and comprehensive evaluation of the facts and circumstances of the case and the client, and then a custom tailored plan of action and a reasonable fee to accomplish the same.
Right. I agree. And I got to tell you, the same thing happens in other law firms. I think, like, for example, I do family law, and in family, same thing. You want to go with a lawyer that's going to understand what you particularly need and tailor it to you. So I agree with you. I think the boutique law firm is what the kind of stuff that we do. The bigger law firms handle, the corporate transactional stuff and some of the bigger stuff, but we do the stuff that's personal. That's what we do, and that's the way it should be done.
And it really is. I mean, it doesn't get more personal than criminal defense litigation, because that is your life. Your liberty, your life is, you are literally, it's like going to a surgeon. You're placing your life in another person's hands, your freedom in another person's hands. And, when you go to a surgeon, you don't want to go to somebody who can't communicate with you, who can't express themselves, who can't explain what it is that they're doing. I mean, I'm not talking about emergency surgery where you don't have the opportunity, but, let's say you get diagnosed and it turns out you have to have a procedure. You want to know that your doctor, you want to be comfortable with the person who's going to be exploring your insides, right? Who's going to be responsible for whether or not you come out of that procedure whole or much less better. And this is, in a way, very much like that. And, actually going back on something that you said earlier, now it just reminded me of that. I was thinking when you were talking earlier about the client telling you how to, what you need to file. Could you imagine you're a pilot and some, guy in 7D, sends the stewardess up to tell you that you should be at a certain altitude, right? or
Move your
the sound
aileron. He's got to change his
right, the
aileron.
sound of the
Move
motor.
your
It sounds like you're off by 300 RPMs on the sound of your motor. I mean, who the hell wants to hear that, right?
And would you? No, and I'm not making fun of people do it because I get it. You're desperate. But think about it. Nobody does that in any other situation. Nobody says to the doctor, okay, so we're gonna have open heart surgery. Have you considered, instead of doing the incision here, that we do it through the, nobody does that, not even with a car mechanic. But for some reason, you're so desperate, and we get it. Michael and I get it. But we could use that time much more valuably doing research, talking, myself, Michael and I talking to each other. Trust me, it's much more valuable for me to talk to Michael about your case.
But,
than for
you
guys
actually
to
just
talk.
you actually just brought up another very good point that I left out. When we consider cases and we talk to the client, again, I'm quite comfortable relying upon my own experience and expertise, as I know you are, Ed. However, once we finish with the client, in virtually every case, I have a core group of trusted colleagues who I run things by regularly. There's three guys that I routinely, three other lawyers, that I routinely run my fact patterns by. And I also run my thoughts and concerns and feelings by. And it's not so much for validation that, pat myself on the back, as it is to see whether or not maybe I missed something. Or maybe there's another point of view that I didn't think of. Or maybe there's a different angle. And so that's part of our calculus too. And I am never embarrassed to go back to a client and say, you know what, here's another thing for us to think about. I would say the vast majority of the time I get it right. And if it's something that I'm not comfortable with, there are some types of cases that I just don't handle with great regularity. Then I will either bring in another lawyer right from the get-go because I don't want to be unprepared or make a mistake, or I will tell the client, this is just not something that I'm comfortable handling. But so that's one. And then the other thing that I will routinely do is, because I am always worried about what if I lose? What if my client comes up short? I always have to worry about possible mitigation right from the start. And so I have mitigation experts that I work with regularly. One of whom is a forensic actually two of whom are forensic psychologists. And so I run my fact patterns by them regularly, particularly when it comes to specifics involving a client's personality or a client's past that may come to haunt the client in during the pendency of a case or at God forbid, at a sentencing hearing. So I seek that advice up front so that I have a better understanding and a better feeling of my own thought process on a given case.
No,
in fact, just today,
again, like everything else in life, nobody sees it as weird. Charlie, so nobody sees it as weird. I actually play a lot of baseball, for example. Go ahead, you go.
I was going to say, we just actually, before we started, while we were waiting to come on this afternoon, you and I were discussing a case that you're working on now. You were watching the body cam and you stopped it and you called me and we spoke for a little while and you told me what you observed. And I said, hey, what about this? And you said, wow, good. Yeah, that's excellent. It's not that you didn't know it. It's just that you were actually helping. Well, I was going to say, you were in, like in that first Star Wars, actually episode 4, right? Stay on target. You were in the zone watching the video, focused on everything else, and it would have dawned on you ultimately. But the fact that you mentioned it to me, it spurred right then and there, and you were like, absolutely, right? These are the things that are very beneficial to our clients. So, I'm not going to send Ed's client a bill for the time that Ed and I spent talking about the case. To the contrary, my follow-up with Ed is, if you want to have lunch and go through it, if you want to send me the video so I can watch it, I'm happy to do that for you. And why? Because he would do the same for me, and because it benefits him and it benefits me. We all win. Yeah. Everybody wins. But the person who wins the most, the client.
Right. Like I said, we're actually helping another lawyer. It's a lawyer friend of mine who called me. And so I'm going through it. I see something. I called up Michael, and Michael, you do the same. You call me sometimes. Say, hey, I'm seeing this. What do you think about this? So these are things that we calculate in. But again, how often am I going to? If we calculated every single minute of what we do, we'd have to charge you 10 times what we charge you. So
Now,
we don't even think about things. We don't charge those.
what's funny is what's ironic is you go to these our producer is texting me. Tommy, thank you, Tommy.
We got 5 minutes.
We're on it.
5 minutes.
Yep. We're going to wrap it up even faster now. We're going to wrap it up in 4 minutes just for you, Tommy. I'd ask if you can hear me, but I know you can, Tommy. So now I lost my train of thought. I just got wrapped up in the Who, and now I got my whole train of thought completely disheveled. But while we're winding down, why don't we wind down and just say that really what we did today was a last minute impromptu kind of show, which I think are sometimes the best shows, because the truth is we didn't plan this or think this out. We had something completely different scheduled today. So what you're getting is really what you got was really raw, unadulterated thought of our thought process and the mechanics of how it is that we come to quoting fees and figuring out how we get it done. I know what I was going to say. I was going to say in civil law firms, they have to map every minute. And I know, I mean, from my own experience of having dealt with them as a client and from all of the people and clients that I know in this world that bitch about it, rightfully, it's not even wrongful bitching, it's rightful. I just got a bill for 0.1 hours because I called my lawyer. Yeah, exactly. Guess what? You're never going to get a bill that says 0.1 hours for talking to Ed or I. It ain't going to happen. And that, by the way, it's not just Ed and I. That applies to virtually every criminal defense lawyer. Not all, but most. Because, again, flat fees just make it a lot easier. When I'm going to go back to what I started with, which is wearing my businessman hat versus my lawyer hat. It is a business decision that it is more important for me to wear my lawyer hat than my businessman hat. So the less time I have to spend worrying about the office and the bills, the more time I have to spend worrying about how am I going to beat this case and accomplish your realistic and reasonable litigation objective. I think I speak for Ed when I say that that's our priority. Yes?
Absolutely. Absolutely.
So with that said, we're going to give Tommy 2.5 minutes early. We're going to thank you guys for paying attention to us and listening to this episode 16. I hope that it was a fantastic voyage. Again, unfortunately, you guys didn't get to look at Raquel Welch, which certainly is my favorite part of the movie, The Fantastic Voyage. But I hope that we were able to give you some insight and some good, valuable information. At least things that you can talk to your lawyer about. And I don't care if it's a civil lawyer or a criminal lawyer. It really doesn't matter. Because the thought process kind of has to be the same. If they're not thinking this way about you as a unique individual and your case as a unique case, you probably want to talk to another lawyer. Yes?
Absolutely.
Concur,
All right,
Doctor?
everybody. Thank you for watching us. Thank you for watching us. As always, it is at your service with Haber and Martinez, and we'll see you guys Monday.
We'll look forward to being at your service next week, the first Monday of October. Thank you guys again. Have a great day. Tommy, thank you very much.